You're listening to the Subrogation Support Network, a podcast from Mattison, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Well, welcome everybody. This is Gary Wickert. I am not Ashton Kirsch. And Ashton Kirsch is celebrating the birth of Madison Taylor Kirsch, who was born on Saturday, August 24th. So he's taking some well-deserved time off to be with his new daughter. But I do have a guest host here today. Emily, are you there?
Yeah, good morning, Gary.
Emily Bates is MWL's lead subrogation paralegal. She's also our most experienced medical paralegal. And when we get into complex issues about workers' compensation liens and understanding what makes up a lien, what we can recover and what we don't, Emily's the go-to expert. So how are you doing today, Emily?
I'm good. We have great weather here today.
Yeah. Well, for listeners who don't know, I started this practice in Houston back in the mid '80s and practiced there for about 20 years, and then moved everything to Wisconsin. I had some parents who were getting old, which is where I was born and raised in Wisconsin. We started Mattison, Wickert & Layer with Doug Layer and Brad Mattison, and the practice grew from there. Just recently, in July of 2023, I moved back to Texas, and I'm working out of our Austin office. We have offices in LA, Jacksonville, New Orleans, Boston, and our main office is in Hartford. We have an office in Nashville as well. And I moved back to Texas, and Emily and I jaw back and forth because she's enjoying the nice weather now. While it can be 100 here. I'm in the hill country just south of Austin, between Austin and San Antonio. But I have to say that about this time of year, Emily, I'm really looking forward to what is your bad time of year, because down here it's gorgeous, and in December and January, I'm wearing shorts to the office. So there, take that.
And I like the snow, so bring it on.
I do too. I did get tired of shoveling snow, but and the length of the winter as it drudged into March in some years. But I'm a winter cold weather guy as well. But I have to be honest with you, I don't even own a snow shovel. So as far as our listeners are concerned, we are going to talk a little bit today about workers' compensation. This topic came up because Emily and I have both seen a number of our clients missing out on some subrogation dollars in the workers' compensation line because they were told by plaintiff's counsel or defense counsel that certain fees and charges that made up their work comp lien weren't going to be recovered. And we have really done a deep dive into this area and made it sort of a specialty of ours to defend some of the, I don't want to call them non-medical, but some of the non-traditional medical bill charges that you would see in a work comp lien. For example, case management costs, nurse case management fees, medical bill audit fees, rehab benefits, nurse case worker fees. What are some others, Emily?
Rehabilitation costs, utilization review charges, med legal costs, workers' comp attorney's fees, et cetera, et cetera.
Yeah, and as trial lawyers fight harder and harder to recover more and more for their clients, and nobody begrudges them of that, that's their ethical duty. Our job as subrogation counsel is to maximize your recovery and to protect those things which you have had to pay out as a result of a work-related accident and recover them in a third-party case. And I have found a lot of confusion around the country. The laws and the liens look different from state to state, but I've seen sort of a rash of insurance companies giving up on recovering of some of these costs. So we'll talk a little bit about that because I think it's become somewhat of a epidemic within the subrogation world. And then we are also going to talk a little bit about another phenomena or other phenomena that are occurring, including, and we see this a lot more often, companies which are known as catastrophic case management companies or outcomes-based case management contractors. These are companies that will contract with an insurance company on a catastrophic loss, serious medical injuries, paraplegia, amputations, serious high reserve, high dollar cases where the unknown is what kills an insurance company. So to make the unknown known, they can contract with a company to provide them with a a dollar figure to cover all medical for the life of the claim. In other words, the company could bid $500,000 or $1.6 million, and actually the insurance company would then pay the company based on a contract they enter into, and from that point out, the outcomes-based contracting or catastrophic case management company is responsible for paying all the medical. And then, of course, the question is, well, what happens if the medical doesn't get to that amount? If they pay $1.6 million to have the company take care of it, and the medicals only turn out to be $725,000, that's called profit, and that's how these companies are in business. By the same token, they take a risk. And that risk is that if the amount that was paid to handle the claim is exceeded by the amount of medical bills, in other words, the $1.6 million that was paid, the medicals in that case actually amount to $2.5 million. That's called a significant loss. So as you can tell with these companies, prognosticating and estimating and putting a value on the future reserves, medical reserves in that case, are extremely important. But these companies do give some certainty to the insurance company. Emily, what are a few of the companies that that handle this kind of work? I know we've used them.
I know Paradigm for sure, and I think a couple that other ones we talked about was perhaps Corvell, International Medical Group, maybe Sedgwick. Paradigm for sure. Conduit
Right.
maybe.
So my cell phone just rang. It was Ashton. I guess I should call him back. It's his show. Yeah, so these are the companies that will actually enter into this kind of arrangement. Hey, Ashton, we are actually live on your podcast right now. Yeah. Well, I didn't know if you were calling in to here, I'll put you on speaker. I didn't know if you were calling in to be a guest host. How's Madison doing?
Everyone is awesome. I'm great. Just actually taking Isla over to the park right now.
Awesome. Well, we'll let you enjoy that. We're Emily and I are in the middle of a podcast. We're going to be talking about these outcome-based contracting companies like Paradigm and others, and how we can maximize our recoveries.
Keep it going. I'm here for you.
All right. Take care. That actually was not planned, but that's kind of cool. So, yeah, we have these companies who come in, and then what happens is we'll get a third-party case will settle, and plaintiff's counsel will say, well, how much is your lien? Depending on the state, we may have a formula that we'll have to follow, or we're going to get a certain portion of the lien back. And so Emily reports to me and says, well, Gary, it looks like we only have $13,000 in medical. And you go, wait a second. Well, what is this charge here for $700,000 to Genix or one of these complex case management outcome-based contracting companies? And the thing that we have to remember is that the laws in every state allow us to subrogate for medical benefits and indemnity benefits with minor exceptions. But when you produce an invoice that says $700,000 paid to Paradigm or to Genx, that really isn't a medical bill. That's a fee paid to a company in exchange for them assuming payment of the medical bill. So that means that we being MWL as your subrogation attorneys, or Emily who is one of the paralegals who will be involved in making sure that this lien is cleansed and contains only those things which we are allowed to recover for, and we'll talk about those more as we go on today. But we are not allowed to recover that fee itself. So now we have to cooperate with these complex case management companies, and they have to cooperate with us so that we can get the medical bills and we can get the amounts and we can get the payees. And one of the reasons that this can become a little sketchy is because these companies aren't thinking subrogation like most insurance, workers' compensation carriers, insurance companies are. They're not thinking subrogation. I've always told our clients that you should be thinking subrogation from the moment the first notice of injury comes in. Why? Well, for the obvious reasons that you want to corral the evidence, you want to preserve documents, you want to investigate quickly before evidence disappears, memories fade, people travel and disappear. But more or as important, I would say, we want to think subrogation then because which state's benefits you decide to pay under can mean the difference between recovering all of your lien, no matter how large or small, and none of it. So it's vitally important to start thinking subro from the moment that first notice of injury comes in. And it's also important if you are going to contract with one of these outcome-based companies that we make sure they understand that we are subrogating and they will be called upon to take the time to provide us with all of the documentation, because they don't necessarily automatically think that they're being paid for that. They're being paid for the risk of paying all these medicals and maybe coming out a winner and maybe a loser. It's a Vegas bet for them. But they are not thinking ahead to subrogation. And as we all know, there can be a lot of work involved in subrogation. So let's just stop for a moment and talk about the typical lien when a plaintiff's attorney asks for proof of your lien and you send them a lien ledger, and that ledger contains a payment list, both medical, indemnity. It could be some other things. It could be litigation costs if you have work comp defense counsel. It could be subrogation counsel if they're working and have some expenses that have been billed to that claim. But what's important is to understand what can and can't be subrogated. So what I'm going to do, and Emily, if you don't mind, can you go through with us some of the entries that you might find in these lien ledgers that plaintiffs' attorneys have historically said, wait, what exactly is a medical legal evaluation? Because they, for example, if in IME, they're going to say, well, an IME isn't medical. That's not for treating the injured worker. That's actually for getting an expert to say, okay, we can stop paying. So, Emily, why don't you go over some of the things that we might find in those lien ledgers?
Yeah, and I know generally speaking in the past when you and I have discussed this, we kind of had it come down to where if it benefits the claimant, it's usually recoverable. If it benefits the carrier, it's usually not. Of course, that depends on the state, but that's kind of how I've trained people to review the payment listings. And one of the big things that plaintiffs' counsel question in pretty much every state is the nurse case management costs. And what we found is there are actual nurses that are responsible for planning and providing efficient and high-quality health care, which involves assessing new patients, updated health care plans as needed, and then they work closely with the families about health care and their options. They might make clinical decisions, document and submit medical records, and they also report back to our insurer. So while it definitely helps our insurer because it's a main hub for information on the employee's treatment, I think it also benefits the employee because they have a constant with them throughout the whole process. They can ask them questions, confide in them, and they can also know that the nurse is acting in their best interest. They can get very comfortable with them. So I think there's an argument to be made that we can recover nurse case management costs. And I know some states have adopted that. One of the lines you might see is medical case management, and this is more so, it'd be payment for the catastrophic and complex outcome-based contractors and vendors. So in a lot of cases, it's actually nurse case management and they code it wrong. So when you see nurse case management or medical case management, that's when you go back to the client and ask specifically, what are these payments? Another big thing you'll see is like medical or bill review fees, and that's when they're examining the medical provider bills and either figure out if they can disallow or reduce charges. There was an estimate I saw that there's actually up to 80% of medical bills that contain errors. So the benefit of this would be for the insurer to not have to pay for mistakes. And I would consider that a carrier benefit, so that wouldn't be recoverable. And then, yeah, as you mentioned, for the independent medical exam, that's to just get a gauge on the claimant's treatment, and that's more so a carrier benefit. Another thing was, go ahead.
Well, I was going to say that judges who will have to decide whether or not a lot of these payments, which can add up to a significant amount, are going to be recoverable by you. These judges, whether they be state, federal, magistrates, what have you, and even mediators, when you're trying to convince a mediator to work out a settlement that includes another $50,000 in things that aren't neatly labeled medical expenses. It's important that you have an argument. I think Emily would agree that there's only a handful of jurisdictions right now that have pat answers for us. What does that mean? That means that, a few states have decided this issue, and not always in the industry's favor. For example, Illinois has totally ignored the cost savings to the claimant of such case management fees and expenditures, and it's sort of declared that these items are not going to be recoverable because they were presumably provided for the benefit of the carrier and were not reimbursable necessary medical or rehabilitative services. There's a case from as far back as 1995 that sort of pours cold water on that. And in that case, the issue was the medical rehabilitation coordinator services of a licensed nurse. And they said, well, that's not necessarily for the benefit of the employee. It's for the benefit of getting that employee out of the hospital bed and into the workplace as fast as possible. But isn't that for the benefit of the employee? So my point here is that while we have limited black and white answers, and Emily can continue with her listing of some of these things that don't neatly fall into a med expense or indemnity category. But the best thing that we can do is make a cogent argument But so having said that, go ahead, Emily.
Yeah, the only other one I was really going to talk about making arguments was you'll see utilization review charges on payment listings, which is the review of actual medical services provided to the employee to determine if it's a medical necessity and appropriate for the injury. So there's no precedent on that. We might keep them in our payment listing and later argue these, that they help keep medical costs down and in turn keeps our lien to a minimum.
Well, and that's another one of the great arguments that a work comp carrier should make, is that a lot of these things are designed to hold down the lien. Well, that benefits the carrier, the judge will say, or plaintiff's counsel will say. Well, yes, but it also benefits you because every dollar that we spend is a dollar that's taken off the top, depending on the state, of your third-party tort recovery, Mr. Plaintiff and Mr. Plaintiff's attorney. So it's a rather specious argument to say that, well, that just benefits the carrier. Anything that can keep the lien small should be included in the lien, because if the carrier doesn't utilize those tools, then the lien can increase, and the next thing you know, plaintiff, the employee is not recovering much of anything. And just my little public service announcement, and I do this to all of my clients whenever I'm talking on a topic that's work comp related, is let's not feel so sorry for the plaintiff. Yes, it's tragic. There was an accident. And if there's subrogation involved, then there was some third party responsible for it. And if there's a recovery, that means the employee wasn't totally at fault. But let's also understand that the employer is the one stuck in the middle here. The employer, and this could be a large employer like Amazon. And this week, our firm is going to be out in Vegas talking to the Amazon delivery service partners for Amazon on all of the subrogation potential for all of the millions of Amazon delivery contractors. And by the way, they're all contractors. It used to be Amazon employees, but not anymore. So we have to come up with an argument for the recovery of these things. And judges likes things to be in neat categories. But my public service announcement is that the poor employer like Amazon, or it could be Mrs. O'Leary, who has her whole life she's wanted to open up a parakeet shop, and all of a sudden she's got one employee, and that employee falls off a ladder and becomes a spastic quadriplegic. Or Mrs. O'Leary, who probably nets $35,000 a year out of her little parakeet shop, which is more of a hobby than anything. Or it could be a family that depends on a small business to make a living and to send their kids to school, is stuck with, through no fault of their own, paying millions of dollars in medical. Oh, but they have insurance, Gary. Well, sure they have insurance, but insurance companies aren't volunteering to pay these things. These companies have to pay significant premiums in order to get the work comp coverage. And the number one expense of small businesses across this country, aside from payroll, is workers' compensation insurance. It is a huge, huge obstacle and prevents many companies from even starting a business. So I always like to throw that PSA in there, because we have to remember these employers, they have done nothing wrong, but now they're stuck in the middle because somewhere back in the early turn of the last century, we decided as a country that we were going to adopt this somewhat socialist program known as workers' compensation. And yes, it was born in the midst of a progressive surge in the early 1900s. And it isn't exactly fair that the employer should be on the hook for unlimited medical. So anyway, I say that so that we don't feel too sorry for the employee who is absolutely covered, even if everything was his or her fault. So Emily, when you have worked with some of these outcome-based contractors that we've discussed, and you get their lien ledgers, there's no two lien ledgers that are the same. Isn't that right? It's almost like you have to read their language.
Each company seems to have their own payment listing, and then you'll also see a lot of payments that are actually coded wrong. So you want to look at pretty much every single payment just to make sure they're not putting it like an expense category when really it was an ambulance and we should be paying that.
Right. And by the way, when plaintiffs' counsel, if you don't have subrogation counsel, and there are only a handful of states where you can possibly get away without being represented, because throughout the country in all 51 jurisdictions, 52 if you include the Federal Act and the Longshore Act, the laws have been slowly mutated to favor the employees and at the expense of the workers' compensation carriers. What do I mean by that? States like Georgia, where they have codified the made whole requirement into the subrogation rights of the work comp carrier, which is really sort of ridiculous because this isn't ordinary subrogation. There's a handful of states, I'd say probably 6 or 7, that have some form of made whole requirement before the work comp carrier can recover its lien. And the made whole requirement is an equitable defense to subrogation, which in itself is an equitable doctrine, but work comp subrogation is not equitable. It is written word for word by a legislature who understands that these employers have to pay, i.e. their carriers have to pay all of this money because of a law that was passed in 1917 or 1922. So it's important that we educate these judges and actually the legislators as well. And we have done that at MWL, sent countless letters to the legislators on both sides of the aisle in a number of states where they have come up with some piece of legislation or a House or Senate bill that hurts subrogation, and most of them don't even know what that word means. So education is vitally important. But as Emily said, these lien ledgers can be all over the map. And when you get them, it's important to be able to explain to the plaintiff's attorney or to the judge or to the mediator exactly why we are entitled to recover them. And as I said, there are very few states that have a rule that you can point to and say, we can recover them, we can't recover them. What you have to do, as Emily said, is make an argument where there's no clearly established rules. So your only tools are the statutory language and common sense. For example, in North Carolina, the statute there refers to compensation as the money allowance payable to an employee or to his benefit or to his dependents as provided for in this article and includes future benefits. Now, that's because the subrogation statute in North Carolina, refers to subrogating compensation. And whether, that includes medical expenses, those are debates that lawyers are having in states across the country as well. But in Oklahoma, for example, there's a Court of Appeals decision in 2022 that really is a good example of how to extrapolate, say, the recovery of nurse case management fees. Oh, those nurse case management fees are not benefits under the Oklahoma Act, plaintiffs' counsel will say, because they weren't paid to take care of a medical bill that was incurred for the treatment of the plaintiff. Rather, this is a nurse who was hired by the insurance company to help coordinate the treatment, facilitate the timing. They're sort of like the logistics of medical in a work comp claim. But in this particular case, which is Jones versus Cabler and Hobby Lobby, the employee argued that the work comp carrier, was not entitled to reimbursement for these nurse case management costs because they were not a, quote, benefit paid, quote unquote. And that's a term taken right from the statute, the subrogation statute. It allows the carrier to get reimbursed for benefits paid. Well, it's not a benefit. The employee didn't get it. The nurse case manager got it. So what in this particular case, the employee's argument was that Section 113, 85 Ohio Statute 113 says that case management costs are to be borne by the employer or insurance carrier. And the court dismissed that argument by indicating that medical expenses and indemnity benefits are to be borne by the carrier until such time as there's a third-party recovery, and then the carrier gets reimbursed. So what they said is that although nurse case management fees are initially borne by the carrier, the statute does not say that the carrier is not entitled to reimbursement under their Subro statute, which is Section 43. So the employee, or I should say the employee's attorney, also said, well, those nurse case management fees are not, quote unquote, compensation either, because the statute in Oklahoma defines compensation as, quote, the money allowance payable to the employer to his or her benefits, and includes the medical services and supplies provided for in Section 50 of this title, as well as funeral expenses. So now we turn to Section 50, and it says that the employer shall promptly provide an injured employee with medical, surgical, hospital, podiatric, chiropractic, and nursing services reasonably necessary in connection with the injury received by the employee. So you can see how there is a way, an argument that you can make, that you can work into that definition, the nurse case management fees and some of the other fees that Emily was talking about. So the Court of Appeals in that case indicated that the employee admitted that a medical case manager facilitates communication between medical service providers and the adjuster and is chosen by the claims handler to make his job easier. And so bottom line is we have to make an argument in each case in favor of allowing us to recover those items. I don't know, Emily, if we, I'm not sure how often this happens, but when you get a lien, do you often have on there legal costs as well?
Yeah, so there's going to be workers' comp defense fees, claimants' counsel fees, subrogation fees, and then so people are just going to have to differentiate between what's recoverable in those instances, which claimants' counsel fees are recoverable, including costs like deposition, since it's benefiting the employee. Then on the other side of that, workers' comp defense counsel fees and costs are not recoverable, since it's benefiting the carrier.
Right, and that makes sense to me because the work comp carrier is hiring an attorney to either defeat the claim, i.e. maybe it wasn't in course and scope, or to limit the amount of permanent partial disability and ultimately permanent or temporary total disability and permanent partial disability, or T&P if the case is there. We have, I don't remember ever seeing a plaintiff's attorney go, oh, of course you can recover those claimants' fees. Emily said they're recoverable, but they're not. You can't point to a statute that says they are recoverable. In some states they are, but in other states it's simply one of those unknowns again. Now, what I like to do in the case of attorney's fees is say, let's look at the state's work comp laws. Is an award to the claimant made to the claimant, and then the claimant owes the attorney, his work comp attorney, a certain percentage out of that award? If so, it's easy to argue that those payments to the attorney even though the employee isn't getting them, were paid to the employee. An employee doesn't have to have a lawyer in his work comp case. He may decide to open the TV guide and find one and go out and hire one, but that shouldn't mean that the work comp carrier should bear the cost of hiring his legal professional. So what I like to do is look at the states and find those states where attorney's fees are paid as a lump sum to the employee, and then statutorily there's a percentage that goes to the attorney. And if a lot of times that's just handled automatically, the statute says, or the commission rules say that the work comp carrier can pay the attorney directly. Otherwise, there may be problems getting paid. But the truth is that those fees are paid to the employee in the form of disability benefits and indemnity benefits, and then they're technically paid by the employee to the attorney. And in those states, I think that the attorney's fees should be included in the lien always, but yet it's going to be one of the hardest sells. In Texas, for example, and this varies from state to state. It's usually governed by state law or sometimes regulations. But in Texas, an employee's attorney is paid fees by the carrier out of the income benefits received by the employee. This means that they're paid out of the benefits that the employer receives in a settlement or award after a contested case hearing. It doesn't include the value of medical benefits or any undisputed benefits paid without the lawyer's help. But the amount of attorney's fees must be approved by the Division of Workers' Compensation in Texas, and they're determined by the attorney's time and expenses. So once the division approves the attorney's fees, the carrier is ordered by the division to deduct, and here's the key part, to deduct the fee from the amount owed to the employee, up to 25%. So it's real easy under the Texas Labor Code and the Texas Administrative Code to say those benefits, those attorney's fees, are actually paid first to the employee as indemnity benefits or some sort of permanent partial award. And then there's an order that 25% of those should be withheld and paid to the attorney. So that is a very contentious topic and one that you will almost always get pushback on. Now, one of the things that our firm has done, and we want to make all of our clients aware of it, is we have produced a chart that is on our website entitled Which Workers' Compensation Benefits Can Be Recovered. And what's important about that chart is earlier we talked about the tools that you have available to you to make an argument that these sort of offline benefits like nurse case management fees and things that Emily went through, that they can be recovered. And what we do is we give you the tools in this chart. We give you the statute. First of all, it says what can be recovered. And secondly, we'll give you the argument for including them in the lien. And then we'll also address the attorney's fees. Are attorney's fees paid direct to the attorney or are they paid out of the award? So those are some of the tools that you'll have to use, as well as really common sense. I was in Mark Twain, who once said that whatever you say it with conviction. That little aphorism is true no greater in any situation than in this situation when you are trying to convince a mediator or a judge who has never he or she may never have run across this issue before. How can that possibly be, Gary? Because there's so many complaints. Well, it's because the arguments aren't being made. Because unless MWL is handling it and we're prosecuting it, and we're trying to maximize recovery of the lien, a lot of our clients, and it's through no fault of their own, because you have to come up with a creative argument. And plaintiff's counsel is going to be adamant that it's bad faith to try and include these things in there. So the argument isn't being made as often as you might think. And as a result, we end up with bad law. And a lot of these judges haven't even seen that argument being made before. But let's go back for a moment, Emily, to the paradigm or to the catastrophic claims management companies. And have you had, without naming names, because some of these companies are clients of ours, have you had difficult experiences in working with some of these outcome-based contract companies as opposed to a work comp carrier?
What I keep running into is our carrier doesn't understand what's going on. I don't know if they know that there's a contract that exists, but when we ask them for Paradigm's payment listing, they're a little, or whatever company, they're a little thrown off guard, and then we explain the process to them. And then when they go to the catastrophic company kind of pushes back because that contract amount could be proprietary. They don't want to let the carrier know how much they've paid in medicals. So I know that there was a file you and I had worked on where we had to go up the chain to Paradigm, and I think the corporate rep even had to testify to the damages. So I don't think the Paradigm companies or complex case management companies fully understand what it is we're trying to do yet. But I know in the last few years working with you and on your files, we've been able to get them to understand. But there's still companies out there that are questioning, why do we need to know the contract price? Why do you need the amount of medicals, et cetera?
And have you found a difference in the way that, and let's just throw out a name, let's say AIG, how a work comp carrier, say AIG, categorizes, organizes, lists, and adds all of these medical indemnity benefits into one document, which we'll call the lien ledger or the printout for lack of a better explanation, and the way Paradigm does it. Have you noticed any difference in the mode that they each use for creating this lien ledger?
Well, they have separate ledgers.
Go ahead.
But I was just going to say they have separate ledgers, and then we have to figure out how the Paradigm payments match on the AIG ledgers versus the medical payments we get from Paradigm. And sometimes they don't match. So that's, I think, where we need to figure out, is AIG reflecting the contract amount on their payment listing versus is Paradigm only showing the medicals paid? So that's why it's important to know the contract price to see if there's any to see what the difference is between the payments.
Right. And before you can even get to this point, it's important that our clients know that there is an inherent danger if you are to do what has happened on multiple occasions across our country, whereby a work comp carrier, maybe without work comp counsel or subrog counsel, has provided a lien total to the plaintiff's attorney, and that lien total is not really the sum total of the medical benefits and indemnity benefits paid. Case in point. There's an Illinois federal court decision called Ocampo versus Paper Converting, and it was a federal case back in 2005 in which the work comp carrier had a past lien of just over $450,000, which included a $431,000 payment made to a contracted case management company. And this case management company contracted, like we described, to manage medical costs, coordinated medical care, and to pay all the medical care providers. They did their Vegas roll of the dice. The case did not really tell us whether they came out ahead or behind, but they acted as third-party administrator. They assigned a nurse case manager, and out of the contract price, they ended up paying only $241,000 for the employee's bills. The remaining of the contract price was the company's profit. So the work comp carrier gave them that full amount, which was the contracted price made to the case management company, and they promptly got sued. The work comp carrier did, for fraud. And it was quite a fiasco because in hindsight, the carrier should have communicated with its vendor and verified how much it had paid in medical expenses as opposed to claiming the full lump sum. So when a work comp carrier decides to contract with one of these companies, and by the way, the wisdom of doing that is beyond my pay grade. I mean, we are talking decisions made that involve a significant amount of money, as well as sticking your finger, wetting your finger and sticking it in the wind and trying to determine whether medicals will be above or below 450,000 or millions. And these companies serve a valuable purpose because now the work comp carrier not only could come out ahead on that deal, and it provided that all of the medical bills are promptly paid and that the employee gets the same service and focus on rehabilitation, getting him back into the workforce and a full recovery. It's a valuable service. So I'm not meaning to demean these companies at all, but the work comp carriers have to be very careful not to claim that fee they're paying to these contracted claims management companies is the benefits, quote unquote, that were paid, because it's not. It's a contract fee, no more, no less than buying a house or, paying someone to build you a new house. It's just a fee paid to somebody for a service. The actual recoverable amount is and was then and will always be the actual true medical bills. How much did Sacred Heart Hospital charge for the 36 days in intensive care? That's the number you want. And when you get the ledger, another thing to be conscious about is you want to pull that number off of there. You want to do as Emily described and fully explain what those other medical payments are and why they should be considered benefits, i.e., make your argument, see Mark Twain. But you also want to maybe white out and redact, and Emily does a lot of redacting, and she teaches our work comp paralegals how to redact these payment logs, because you do not want the other side seeing, say, reserves, indemnity reserves, because it's a peek into the soul of the insurance claims handler and what he values that case as. Emily, any comments about lien redaction or what that process is like or what you recommend?
Just removing what we believe is the unrecoverable items and communicating with the client why we shouldn't be including those. In most cases, if we do get a payment listing over to plaintiff's counsel or whoever, they do a very good job at pointing out what they don't think they should pay and why. And then we have to go back to the client and either let the client know they're wrong or, yes, we need to redact and remove those.
All right. Well, this is not the sexiest of topics, but as you can see, not understanding it can lead to some significant claims being brought against a work comp carrier, including bad faith and fraud. And that's true for some of the nurse case management fees and some of the other fees, which may be disguised as indemnity benefit payments or medical payments, but are really not. So knowing what can be recovered and what can't is vital. Again, our chart is called Which Workers' Compensation Benefits Can Be Subrogated? And recovery of case management costs, medical bill audit fees, rehabilitation benefits, utilization review costs, IMEs, nurse case worker fees, attorney's fees, and other quote-unquote allocated lost adjustment expenses. I think if one of the mistakes, if I were asked after 41 years of doing this, in this industry, one of the most common mistakes is, in a nutshell, simply put, it's that a lot of our clients assume that subrogation is very simple. Someone else is at fault, plaintiff has sued somebody, let's provide them the amount and we'll recover the money back. Nothing could be further from the truth. The plaintiff's bar, trial lawyers have made sure that this has become a complicated battleground. And they do that because they are trying to create fissures and inroads into our ability to recover these payments, not just in work comp, but across all lines of insurance. So we have our job cut out for us. Emily, any last thoughts before we sign off here? I really appreciate you joining us.
I appreciate you having me. I don't have any further thoughts. I think we kind of touched on everything.
All right. Well, listen, everybody. Ashton will be back next month with the podcast. We're like the guest. I was telling Emily earlier, we're like the guest host. When Rush Limbaugh used to have guest hosts, they'd come in and get behind the EIB microphone and sit in the big EIB chair and talk to Bo Snerdley with about the cigars. And, we kind of feel that way because Ashton has done a wonderful job with this podcast. So Emily, thank you. And we will see everybody next month.